What kind of international system or multilateral system exists in relation to intellectual property rights?
According to World Intellectual Property Organization and our government, Indian patent laws as are at present or modified version would be perfectly compatible with Paris Convention for protection of industrial property. Another tenet of Paris Convention is that Paris Convention insists on reciprocity of treatment based on national standard. That is to say that each country should provide to foreigners same treatment as is provided to its citizens and nationals. Even though India is not member of Paris Convention, we do have system of reciprocity of treatment, and we provide to foreign nationals the same treatment as is provided to Indians in those countries. We do also have with several Commonwealth countries bilateral conventions to ensure this kind of reciprocity of treatment. But the national treatment that is meted in India in terms of our patent law and MRTP Act is absolutely in harmony with the practice of Paris Convention. Paris Convention also has many advantages because of the information flow in terms of technical knowledge that is available to developing countries, and also because of the fact that there is, in terms of policy, legal security created in favor of foreign investment and technology transfer flows. One element of Paris Convention which is important for us to note relates to priority rights. That is to say that if you are a member of Paris Convention and if you have patented your made and patent application in one country, then based on that patent application claims for patenting, within one year you have the right to patent on the same grounds your invention in other countries, and this is the system of priority which protects the novelty of the invention, and this also is not at all nuisible or detrimental to our system of research and innovation and inventive activity. So I think that we should try, in light of these broad features, to properly understand the system of Paris Convention and the debate going as regards India's adhesion to it.
Several developing countries have opened up their economies and have adopted liberalized policies in relation to industrial revolution, investment and imports. India has also done this. Now, what are the implications of a relatively more open economic regime insofar as intellectual property rights are concerned? That is, how do we view, for instance, the Paris Convention? How has the situation changed with economic liberalization, and what is the present thinking?
New economic policies in India, which principally aim at liberalization, delicensing of industry and encouraging privatization, have been spelled out last year by our government. As regards intellectual property, particularly industrial property, certain provisions of the policies are very relevant. For instance, the foreign equity now in our foreign collaboration can be 51%. The aim of the policies has been to encourage our industry, first of all, to be present on international market, also on our national market, and to compete internationally. Because the new economic policies clearly state that Indian industry now has become mature, we must forge, I quote, alliance with foreign partners, and, unquote, we must also try to be internationally competitive. That is the spirit of the policies. In other words, we are more and more going in for collaborative arrangement, joint ventures, foreign investment activities and technology transfer transactions with the industrialized countries. We know it that, for example, in case of foreign investment in this country and technology transfer, our major partners already have been the industrialized countries such as USA, Germany, Japan, France, and other industrialized countries, Sweden, Switzerland, Canada, etc. Now, when we come to the field of intellectual property or industrial property rights more specifically in the context of these new policies, then two set of questions arise for us to consider. One set of questions relates to international technology transfer and foreign investment. I have carefully examined new policies, and we have not really yet stated much as regards the intellectual or industrial property rights arrangements. For example, we have Reserve Bank of India survey, last survey has also come, analyzing for a period of 4 to 5 years foreign collaborations. In our foreign collaborations, whole set of intellectual property rights are mixed. For example, certain collaborations pertain to patenting activity, others pertain to know-how, but most of our foreign collaborations pertain to technical assistance and kind of transfer of technical knowledge, which is predominantly not covered by patenting activity, but which is predominantly one of know-how. Now, know-how as such is a matter of business confidentiality, and it's protected only so long as there is a contractual obligation to protect. So, I feel that unless we were to go into thinking of additional policy framework in relation to intellectual property right, where we would provide for better business negotiation tools in terms of management of intellectual property, we may not be competitive in terms of these international technology transfer transactions. That is one dimension. But if we look into our domestic market and domestic capabilities in science and technology and our domestic system of intellectual property right, then as I mentioned, we have to look also into private sector industrial R&D. Now, it is well known, I have also highlighted that R&D expenditure in industrialized countries is going very high, particularly private sector R&D, by way of international collaborative framework between big firms. But when we look at Indian scene, we find that our R&D expenditure is very, very low, practically non-existent vis-a-vis the industrialized countries. So that one implication, an important one in terms of new economic policies for India would be to effectively encourage the private sector R&D expenditure. We do have schemes of incentives administered by our government to encourage this, but there are lacunas and gaps in this, and our Science Advisory Council to the Prime Minister has also pointed out 2 years back in their document on prospective planning that the system of rewards and incentives provided to private sector is not effective. So this domestic kind of promotional schemes for R&D and for intellectual property creation is another dimension. As far as intellectual property creation is concerned, there is already debate going on about improving our patent system. I think that we do not have as yet as strong culture of intellectual property creation and patenting as in other countries. For example, we are very good in our engineering capabilities. We are also in our university and technical institutions very good in terms of excellence manpower. But if we were to give it a legal basis for creativity as manifested in intellectual property right, that probably will make us better partner vis-a-vis the industrialized countries. We must also keep in view in this connection another development, and that development is that the intellectual property rights now are becoming what is known now as intangible assets. That is much more a matter of blueprints, designs, data processing, engineering services, etc. Things which are intangible rather than material or machinery or tangible things. And in this trend, global trend of overriding, which makes the intangible assets of overriding importance, I think India can really become a good partner, provided that we were to devise suitable policies and mechanisms, of which intellectual property right is certainly going to be a crucial one.
Till now, India has been somewhat reluctant to sign Paris Convention in respect of intellectual property rights. The main cause was that India was insisting and has been insisting that they should have process patenting only, not product patenting, in respect of essential commodities, particularly like pharmaceuticals and drugs. If it is only process patenting for Indian manufacturers, it is possible with some modification of processing to make their own product and thereby to market a much cheaper price. But now the situation has changed. You know, the preference about product processing and process patenting also changes the situation. If we have to export in a big way, then product patenting is essential for us, because that will protect us from patent violation by other countries. But if we have to import in a big way, then possibly process patenting is better for us. But nevertheless, in India, as you know, we have started exporting many items in a big way. In respect to those items, possibly product patenting is better. Nevertheless, apart from this change, in which we are now looking forward in exporting in a big way in future, there has been many changes the world over. The economy is integrating. There is much greater interdependence between the countries. One country cannot live in isolation. Research and development has become very expensive. It is necessary to spend much more and therefore to get a better return out of it. Therefore, there is a rethinking now that even with regard to product patenting, India should have a different view, and they may think in terms of joining Paris Convention. The other important change that has taken place is that Paris Convention is no more considered in isolation. It is going to be a part of a bigger GATT negotiation. And therefore, when we think of Paris Convention, we have to think in terms of multilateral agreement under GATT. Paris Convention alone cannot be by isolation a factor. These changes all over the world have induced India to somewhat remodel their thinking and to start thinking in terms of joining Paris Convention.
Japan has made rapid strides in economic progress, and this is mainly, as has been argued, due to their recognition of and respect for intellectual property rights. The example of China, which has accepted Dunkel draft, is also cited. The Dunkel draft, prepared by Secretary General of GATT, Mr. Arthur Dunkel, is a document of nearly 500 pages. Which contain various proposals on trade and tariffs for the acceptance of the member nations. The provisions relate to trade, tariffs, or intellectual property rights, whether related to trade or investment. It has been argued that China, by adapting its economy to the demands of international trade, has been able to attract greater foreign investment. Example of Italy is also given. Italy's economic situation in 1978, when Italy went in for patent protection, domestic companies did little R&D. They were mainly sales-oriented. Plagiarization of foreign company products by the locals was quite common. But today it has been stated, Italy can hold its head high for its intellectual honesty. In the light of this, therefore, it is contended that India should come to be known not as a country of pirates of technology, but as a country of innovators and inventors, and as a country which provides a strong protection to intellectual property rights. So how can we analyze India's attitude towards overall GATT negotiations and the recent Dunkel proposals? Are there any provisions in the Dunkel draft which are likely to hurt our national interests?
As you know, GATT is a body of 108 members. With increasing international economic activities and with much greater interdependence on economic issues, as I said earlier, intellectual property right will not be considered in isolation. it is going to become a part of overall GATT negotiations. GATT negotiation is not confined to intellectual property right. There are many other areas which are being considered. I will deal with only 2 or 3 important areas. One is market access. In respect of market access, GATT proposals are definitely in favor of developing countries, including India, that safeguards their interest as against developed countries. The other important area is agricultural prices and agricultural subsidies. As you know, in respect of most of the European countries, particularly belong to the European Common Market, they give high subsidies on all agricultural products, which keeps the price of agricultural products depressed all over the world. This has been a bone of contention between United States of America and European Community. America wants these subsidies to come down. European Community is resisting it. I think somewhere in between a deal will be struck by which over a period in course of time subsidies will be reduced. If that happens, that will be very much in favor of countries like India, who should be able to get much better prices for their agricultural products in future. The third item is, as you know, multi-fiber agreement, which used to be a kind of a bilateral agreement between exporting and importing countries of textile fibers, is also going to be merged with GATT. Now here again, bilateralism is being replaced by multilateralism, and therefore there cannot be any arm twisting. Over a period, giving some time, it will be merged. There are some areas which needs to be improved upon in this merger basis, but nevertheless, in terms of principle, if multi-fiber agreement can be merged into GATT, it is going to be in favor of developing countries because it would be multilateral. The fourth important point that is going to happen is that for all the members of the GATT, the performance is going to be institutionalized, and therefore it will oversee who violates, who doesn't violate, who is doing wrong, who is not doing wrong. And instead of bilateralism again, it is going to be given a fair treatment to all the members. So from these considerations, I believe that in today's change situation, when interdependence is rising and when world trade is going to multiply in a big way, there is no other way for any big country like India than to join GATT, of course, with many safeguards in respect of intellectual property, in respect of multi-fiber agreement, and a few other areas. Those safeguards can be discussed, and best possible terms can be extracted. But nevertheless, in today's condition, I see no other way than for India to finally agree to the GATT proposals.
There are 3-4 major provisions which would hurt our national interest. First one, that it is a global package, and which means that this package covers all the aspects of our economic activity, which relates to agriculture, industrial, and service sector. And the package has to be accepted as a whole. Dunkel has said that the countries will have to accept the total package and not part of it. In the earlier rounds, there was possibility of accepting a particular protocol, but now this package will have to be accepted as a whole. The second major aspect is that it is a self-executing treaty. After the Dunkel text has been signed, then the Parliament will have to enact laws as per the provisions of the Dunkel text. The third is about the patentability. Earlier the scope of patentability was determined by our Parliament. Now the scope of patentability has to be related to the Dunkel text, which means that if any area is excluded in the Dunkel text, then only there is possibility of exclusion. Otherwise it is not. As it is, the text provides that it will cover all aspects of technological development. The Dunkel text provides that importation will have to be treated at par with the domestic production. There has to be no discrimination, which would mean that after the patent has been granted to the patent holder, normally he gets the right on manufacture. it's a question of excluding others from manufacturing that particular product. But under this new text, the proposal is that importation will also enjoy the similar right as the domestic production, which would mean that the patent holder may not produce that particular good in the country of grant, as in India. If they take the patent, they may not produce here. They may continue bringing that particular product from abroad. That kind of monopoly would certainly hurt our self-reliance aspect. Ours is a big country, large demands. For that, it's very important that there should be local production, there should be domestic production. So working on a patent is very important, and importation to be treated at par would certainly hurt our national interest.
It is widely believed that indigenous R&D would be undermined by Dunkel proposals, which instead of process patents seek to introduce product patents in the areas of drugs, pharmaceuticals, chemicals, food, agricultural products, plants, animals, and nuclear technology materials, etc. However, a transition period of 10 years has been allowed for making changes in the patent laws. What are the reactions on this? What would be the role of Indian Parliament for making changes in the patent laws in future?
Yes, in the Dunkel text there is a provision that the developing countries can take 10 years to change their domestic laws. And 10-year period has been given specifically for those countries who have process patent. In addition to this, there is a provision also that immediately after the signing, when the text come into operation, the intending patent holder can put up application for product patent. In addition to that, there is also a provision during this transitional period that the patent, those who apply for patent, they can go in for marketing, exclusive marketing approval, and that this marketing approval would be given for a period of 5 years. So during this transitional period of 10 years, our patent law would be totally eroded, and during this 10-year period, industrial activity on new product would totally come to standstill. 10-year period virtually has no meaning to us. In addition to this, when the text has been signed, Paris Convention provision also will have to be applied suo motu. And there's a provision in the Paris Convention about right of priority. And the right of priority provision extends even 1 year before the date of application. So virtually, this transitional period has no meaning. Dunkel text is a self-executing treaty, which means the domestic parliaments, the parliaments in the contracting parties, they will virtually have no role. Whatever is provided in the Dunkel text will have to be enacted into a law by the various contracting parties. The sovereignty of parliament virtually is taken away by the provision of the Dunkel text.
It is also believed that the provision that plant and animal varieties can be patented may have disquieting implications for agriculture. The result can be that the farmers may have to pay some form of royalty for the crops they raise, food may become expensive, and food security in the developing countries may get diluted.
Now in the agriculture area, they are thinking a sui generis system, which is generally applied like plant breeder right. It will apply to seeds. Patenting of seed would mean that the farmers would buy the seeds of new varieties. They will have right over the crop, but not right over producing seeds from the new crop. And if they produce the seeds, they will have to pay royalty to those who have the patent for such seeds. This kind of situation is totally unworkable. Even if they produce some seed after paying royalty, they cannot sell those seeds to others. In the area of animal husbandry, the genetic engineering, there is possibility of crossbreeding, but crossbreeding also, the farmer will have the right over the milk and not right over the calf. The right over the calf will belong to the country, to the company which gives the right for crossbreeding, for genetic engineering.
Perhaps it is in India's interest to have a multilateral trading system in operation. There are perils in having to deal with major economic powers bilaterally. US Law Special 301 and Super 301 have caused much acrimony or anxiety in India. Besides, development needs easier access to imports of capital, technology, products, and services. Eventually, therefore, if India becomes a party to GATT agreement, the crucial question is what safeguards in the GATT negotiations we need to work for or we need to insist upon.
You know, from experience, I can tell you that ultimately India's economic growth, India's success, India being able to export more value-added items will depend not on either joining or not joining GATT, but will depend upon how you yourself in your own country develop. And here possibly we can take a good example of Japan. You know, if we go on borrowing R&D from other countries for indefinite period and not improving upon it, there is no end to it and you will never gain. But a stage must come when you are able to develop and improve upon the borrowed research and development and start selling your own technology to other countries. That is what Japan did. At the initial stage they bought technology from other countries. They not only pursued and implemented it, they improved upon it and they created their own technology. If we really want to grow, then at the initial stage we have many difficulties, but with the resources available, with the talent available, with the institutions available, with a very local major market in India that is available that was never available to a country like Japan, I see no reason why, GATT or no GATT, in course of next 10 to 15 years time, we should be able to develop our own technology to such an extent that India will be a seller of technology in net and not a buyer of technology, and all these terms provided by GATT will become favorable.